Why are you penetrating a 6-year-old with your penis? I mean, you pled guilty to it.
Yes, ma'am.
So I'm trying to figure out, what were your thought process when you were penetrating a 6-year-old with your penis in the vagina and anus?
It was, I know I messed up and,
Well, no, my question is why? What were you thinking while you were doing it? That's what I'm trying to figure out.
Jonathan Rodriguez walked into a Texas courtroom having already pled guilty. The only question left was what came next: prison or a chance to walk. He chose to speak. That was a mistake.
589, State of Texas versus Jonathan Rodriguez. All right, are you Mr. Rodriguez?
No.
Are there going to be any witnesses or just argument?
This argument.
All right, Mr. Rodriguez, you entered a plea to indecency with a child. According to the plea bargaining agreement, punishment is to be assessed at a cap of 15, and there's to be no contact with the complainant and Chapter 62 registration. The state is opposed to your application, state?
Yes, Your Honor. So I'm assuming you proceed with argument, correct?
Yes.
I didn't want to assume anything. So based on the offense date, if you look at the child's date of birth compared to the defendant's date of birth, the child was 6 years old at the time of the offense, and the defendant was 28 years old at the time of the offense. This case is even more aggravated in the fact that this child, when she went and had her SANE exam, the fact that she had a SANE exam is terrible in itself. But as a result of that, she tested positive for chlamydia in both her anus and in her vagina. What's contained in the STIPs, and I believe the court can consider, is that this child said that he penetrated her anus and her vagina. And so it's clear what other way other than some sexual act by somebody does a child get this? And so these cases are already egregious in the nature that we have a child victim whose innocence has been stolen from them. But what's even more aggravating is the age difference of this child was 6 years old at the time of the offense. And what's even more aggravating is the fact that this defendant, presumably, all the evidence suggests that he is the one who caused her to have an STI at the age of 6, maybe 7 at the time of her outcry. And so we are asking, and I believe justice demands that you deny his application for deferred adjudication, and that we ask that you sentence him to the full 15 years because of the aggravating nature of this offense.
All right, defense.
Your Honor, obviously these are aggravated facts, but these cases almost always involve aggravated facts. And I think, Judge, what is going to determine how this case goes is whether or not the court believes that my client is worthy of redemption. And I would say that he is. I am asking that you put him on deferred adjudication. Notwithstanding the horrible mistake that he made, he has no criminal history. He's never been convicted of a felony. He's never done time in prison. He's never done time in county jail. This is his first offense, and it is a horrendous offense. But the fact remains, he has no criminal history whatsoever. Further, Your Honor, if there is deferred adjudication, as the court knows, the court would not be limited to the sentencing range that it's limited today in the event that Mr. Rodriguez were to violate his deferred adjudication. Mr. Rodriguez at that point would be facing the maximum, which I think gives him incentive to behave himself while on deferred adjudication. Also on deferred adjudication, the court can order the treatment that he needs in order to rehabilitate himself. And the court could also order conditions to protect the complainant from the defendant. I'm asking, Your Honor, that you put him on deferred adjudication. This is a horrendous thing. There's not really anything I can say about that. But the fact is, I think he's worthy of saving. He has no criminal history. And I do think that I do think that he could right the ship, so to speak, Your Honor.
All right, anything you wish to say? Can you raise your right hand for me?
Yes, ma'am.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? You can lower your hand. So before you decide to testify, if you decide to testify, the state, of course, is allowed to cross-examine you. Do you still wish to testify?
If I ask you questions, he can ask you questions too. You have to answer. Okay.
All right, what would you like to say?
No, about the probation, if you do give it to me, you know what I mean?
All right, I thought you wanted to say something about the actual
Oh, no,
allegations.
no. I was gonna say about the probation. You know, if you do give it to me, I promise you, Honor, that I'll prove to you, and also I'll prove to my brother that's back there and my mom also. And
Why are you kissing a 6-year-old with your tongue? That's what I'd like to know.
Why am I kissing a
6-year-old with your tongue. I read all of the PSI reports.
I don't remember doing that, Your Honor.
Why are you penetrating a 6-year-old with your penis?
I
mean, you pled guilty to it.
Yes, ma'am.
So I'm trying to figure out what were your thought process when you were penetrating a 6-year-old with your penis in the vagina and anus?
It was, I know I messed up, and you know.
Well, no, my question is why? What were you thinking while you were doing it? That's what I'm trying to figure out.
I just called the name on it.
Okay.
I'm sorry.
I mean, I'm just asking questions.
All right.
All right, defense? Any questions?
No, Your Honor. As the court sees, there's what can he say for this? It's horrendous. I just asked the court to show mercy.
All right, any questions?
I think you said enough, Judge.
All right, this is what the court is going to do. The court is going to find you guilty, sentence you to 15 years in the prison, give you credit for any time served. There's Chapter 62 registration and no contact with the complainant. Showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
That's fine.
Because it's the plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand? All right, we can go off the record. I understand that sometimes people regret what they've done, but we can't turn back the hands of time. So you need to internalize what you've done, and hopefully this won't happen again with you. You understand? All right, is there any impact or no?
No, Judge.
All right, thank you.
The prosecution laid out the facts without hesitation. Rodriguez was 28 years old. His victim was 6. A medical examination conducted in the aftermath of the offense returned findings that confirmed the child's account in full. The physical evidence left no room for doubt. And beyond that, the examination further suggested that Rodriguez had transmitted a serious infection to the child, at 6, possibly 7 years old. The prosecution asked the court to deny deferred adjudication and impose the maximum under the plea cap, 15 years. They argued the case was aggravated in every direction: the age of the victim, the nature of the offense, the documented physical harm, and the medical consequences that followed. Justice, they said, demanded incarceration. The defense had a different framing. Rodriguez had no prior criminal history, no felony convictions, no jail time, nothing on his record. His attorney acknowledged the offense was horrendous, didn't try to minimize it, but argued that a first offense, no matter how serious, still left room for the court to consider the man, and not just the act. Supervised probation, he suggested, would keep Rodriguez under strict court oversight, allow for treatment, and give him maximum incentive to stay in line. The word he used was redemption. He said Rodriguez was worth saving. Then Rodriguez spoke. He didn't address what he'd done. He didn't express remorse for the child. He talked about probation, what he'd do with it, how he'd prove himself to his family sitting in the back of the courtroom. The judge let him finish. Then she began asking questions about the specifics of what he had done to a 6-year-old. Rodriguez said he didn't remember. She pressed further. He said he knew he had messed up. She pushed again. Not what, but why. What was going through his mind in those moments? He said he just followed and trailed off. The judge said, "Okay," and moved on. There was nothing left to argue. Even the defense acknowledged it. What can he say for this? The sentence came down. 15 years in the Texas Department of Corrections. Mandatory registry requirements. No contact with the child. No right to appeal under the plea agreement. After the record closed, the judge added one final note. Not a lecture, something quieter. She told him she understood that people sometimes regret what they've done, but time doesn't reverse. He needed to internalize it. That was all. The defense asked for mercy. The court gave the maximum it was allowed to give. For a 6-year-old whose life was altered before she was old enough to understand why, some would argue 15 years was still the floor, not the ceiling.
We are, in Jefferson County, tired of young people running around here with guns. You put a gun to somebody's head. We're lucky you haven't killed somebody, because that's the path you're on. All this talk of I want to do right and I'm going to do better is just a bunch of baloney.
Pulls a gun on a 14-year-old kid and steals not only that kid's dirt bike, but also a small amount of cash from that 14-year-old. The PSI indicates that 14-year-old is so traumatized by this that he can't even attend public school anymore, Judge. When he was apprehended with that stolen dirt bike, there was a vehicle associated with this defendant. And in that vehicle were other subjects who had 4 firearms in that vehicle, Judge. And as if that was not bad enough, he goes on to brag about this criminal activity on social media. And if that wasn't bad enough, Judge, he goes on to taunt the victim of the UUMV on social media as well. Judge, he is youthful, I'll acknowledge that. He does not have any adult criminal history, Your Honor, I will acknowledge that. But Your Honor, what he has engaged in is beyond the pale. He needs prison time, in my opinion, Your Honor, and that's what we're asking this court to do. If somehow, in any way, shape, or form, the court's considering community supervision, we'd ask for shock probation, some prison time up front, and then shock him out on community supervision.
Mr. Chopin, these cases for me with kids your age are so hard. And I have for a very long time tried very hard to give chances. But all of the guns and the riding around and so you're January 2019, you're put on January of 2019, you are put on probation, juvenile probation. You violated it 1, 2, 3, 4, 5, 6. On your 7th time to violate, they finally sent you to TJJD, right? 7 times you were given an opportunity. You go to TJJD, obviously you're not there very long because you get out, and then in December of 2022, you commit an unlawful carrying a weapon, evading arrest or detention, and you're again put on probation. You're given another opportunity in January of 2023. So in this year, you were put on probation for a gun case and an evading case. While you're on that probation, after you've been to TJJD, you commit these 3 offenses while you're on probation. So none of it makes sense that I want to do better. And I mean, all this riding around with guns and masks and stealing, and it's just crazy. It's just crazy. Go to see in the jury box. I gotta think about this one some more for a minute. So what I've done, in addition to obviously just thinking about it and looking at all of this a little bit more, is ask and get any incident reports that you've had since you've been in custody. And Mr. Chopin, I appreciate Mr. Lewis and what he's done and the arguments he's made for you. And like I said before, it really kills me to what I feel like I have to do to you young people. But we are in Jefferson County tired of young people running around here with guns. You put a gun to somebody's head. We're lucky you haven't killed somebody, because that's the path you're on. You've had opportunities at probation, and unfortunately, those haven't worked. You've actually already had 2. You were sent to TJJD, you got out, you still committed offenses, and then you got probation again, and then you're here. So all this talk of I want to do right and I'm going to do better is just a bunch of baloney. The way you can't follow the rules in jail shows me same pattern. You can't follow the rules. So at this time, in cause number 23 DCCR 0993, I'm going to find sufficient evidence to find you guilty, and at this time find you guilty of unauthorized use of a vehicle. I'm going to sentence you to a term of 2 years in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number, and these were all just open. So in cause number 23, DCCR 0991, I'm going to find sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with the use of a vehicle. I'm going to sentence you to a term of 10 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 23, DCCR 0992, I'm going to find sufficient evidence to find you guilty, and at this time find you guilty of aggravated robbery. Sentence you to a term of 25 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I am making an affirmative weapon, finding of a deadly weapon. These cases will run concurrently, which means together at the same time. So I am denying the state's motion to accumulate, which is a gift to you. I am going to grant the state's motion to forfeit the weapon, which is a Taurus Millennium G2 pistol bearing serial number TIP 10158. I'm going to hand you, I need there should be an admonishment showing that I signed it. It wasn't a plea agreement, but I don't see one printed out. Mr. Chopin, I take no pleasure in giving out a sentence like this, but I feel like what I have to do is protect Jefferson County from people like you, who have continued to show that you're just a danger and becoming more and more of a danger instead of learning from the opportunities that you've been given. You will be handed in just a minute a trial court certification in each of your cases that shows these weren't agreements, so you do have rights to appeal, and you can talk to Mr. Lewis about that. I hope you take advantage of any programs. You're still young. You're going to get out of prison, and you're going to be young still and have a lot of your life ahead of you. I hope what you do while you're in prison is do what you're saying you really want to do, is get your life together. There's programs you can get out. You can have education when you get out. They offer that, and hopefully be a productive member of society instead of going down the wrong path that you've been going. All right, good luck to you. You can go back with the bailiff. We'll get those forms printed out.
By the time this case reached sentencing, the judge had already run out of chances to give. The defendant, identified in court as Mr. Chauvin, stood accused of confronting a 14-year-old with a firearm and demanding the boy hand over his dirt bike along with a small amount of cash. According to the prosecution, the young victim was left so shaken by the encounter that he could no longer attend public school. When the defendant was later apprehended in possession of the stolen bike, the vehicle connected to him was found carrying additional firearms and other individuals. Compounding the situation further, the defendant reportedly posted about the incident on social media afterward, including content directed at the victim himself. The prosecution didn't shy away from acknowledging the defendant's age or his lack of an adult criminal record. But they argued his pattern of behavior had gone far beyond what probation could address, and asked the court to impose real prison time, or, at minimum, a short period of confinement before any release to supervision. What followed was less a contest between two sides and more a recounting of a young man's history with the system. The judge walked through it methodically. An initial placement on juvenile probation in 2019, followed by 6 separate violations before he was finally sent to a juvenile detention facility on the 7th. After his release, within months, he picked up new charges, unlawful possession of a weapon and evading detention, and was placed on probation yet again. While still on that probation, he committed the offenses now before the court. The judge made clear this wasn't a decision made lightly. She described reviewing his behavioral records from custody before sentencing, noting that an inability to follow rules even in a controlled setting reflected the same pattern that had brought him to her courtroom in the first place. She acknowledged the difficulty of these cases involving defendants his age, and said she had spent years trying to extend chances where she could. But repeated probation, a stint in juvenile detention, and continued offenses while under supervision left her with little room to do anything but hold him accountable. The sentences were handed down across 3 separate charges: 2 years for unauthorized use of a vehicle, 10 years for evading arrest with a vehicle, and 25 years for aggravated robbery, with an affirmative finding that a deadly weapon was used. The court ordered the sentences to run concurrently, rather than stacked, a decision the judge described as a benefit to the defendant, and ordered the firearm involved to be forfeited. In her closing remarks, the judge said she took no pleasure in the sentence, but framed it as necessary to protect the community from an escalating pattern rather than a momentary lapse. She reminded him he would still be young when released, encouraged him to use available programs and education while incarcerated, and expressed hope he could eventually choose a different path. 7 violations, 1 juvenile facility, 2 probations, and 1 armed confrontation with a child that closed the door on all of them.